we're talking about bankruptcy notices here. In different legislation, it's when a person owes you money, and at the moment it's over $10,000 to issue a bankruptcy notice, but it changes, and it did change during COVID. And it's quite often the case that that will also attract a positive response in payment if the person has money, from my experience, because effectively you'll have someone, a trustee in bankruptcy, come in and take control of your estate and affairs and sell things that you own to pay creditors, and no one wants that. Plus, it's also a black mark against your name, which will show up at least in public records for at least 10 years. And effectively, a bankruptcy notice is issued to try and compel an individual to pay or a debt or face bankruptcy, and the same time period, 21 days. So, have you had any experience with any of that recently, Rodrigo?
Yes, and different from just simply issuing a statutory demand. You're unable to issue a bankruptcy notice unless you've got a judgment. In order to be able to get to the bankruptcy notice, you first need to issue a claim or a statement of claim or a writ in any of the courts. You then need to obtain a final judgment and order saying that an amount exceeding $10,000 is owed, which then enables you to issue a bankruptcy notice. So you can see the objective of the government and the seriousness that a bankruptcy notice can have, and why it is that they make it a little bit harder in order for a creditor to be able to issue a bankruptcy notice. And understandably, most people have real property in their names, that's their residential home, and bankruptcy can have catastrophic consequences where they end up ultimately losing their home. Having said that, because of the serious consequences that it can bring, again, it applies a lot of pressure on the individual who owes the money, and more often than not, if there is money there or if they got something to protect, they will come to the table and come to an agreement. And again, it goes back to the idea of getting a result for our clients.
And you could also potentially, without annoying the court, maybe carefully call up the registry and find out what the timeframes are on federal circuit versus federal. They are managed by different people, they've got different judges, and find out which one's quicker, maybe.
No, I agree with you.
It's an option. If the client don't care about time or fees, you could go either. But generally, I'll go federal circuit court as my preference. So I had a recent example with a builder that was made subject to a final VCAT order, didn't pay the individual. He was made bankrupt, and he effectively was unable or didn't want to pay his debt, but he had a family home that he co-shared or co-owned with his wife, which we realised had actually been secured to some related party. So it then brings us to our next topic, which is about the powers of liquidators and trustees, and their ability to claw back funds. In this instance, we said to our client, well, the trustee in bankruptcy wants to be funded, wants to receive some money to do investigations and use their powers under the legislation, under the Bankruptcy Act, to try and work out what's going on here with the assets, with the bankrupt, the builder, and they were looking at all sorts of things, and they do have effectively a lot of powers. The main ones are unfair preferences, uncommercial transactions, insolvent trading. So for those out there that don't know what they mean, unfair preference is basically if one creditor was paid whilst others missed out, that payment may be clawed back, generally within 6 months before the liquidation. Or you've got uncommercial transactions, deals where value wasn't equal, e.g. giving away assets, selling it under value, and insolvent trading. Directors can be personally liable for the debts if they kept trading whilst insolvent. So different but similar processes and powers of liquidators and trustees to claw back assets in different scenarios. Depends on the facts, requires a close forensic analysis of the chronology of events and what happened. And I have seen directors repay tens of thousands of dollars after a liquidator could prove that the company was insolvent and still racked up debts, and where we've given the option to the client that they should fund a liquidator, at least to some degree, to try and do those investigations. There's a lot of very capable liquidators and trustees out there. They're very good in that area. They generally know what they're doing, and they will try to work in the best interests of the creditors. So never close the door. Always think that step might be a necessary step. Have you seen any situations or examples, Rodrigo, where through that process, a liquidator or a trustee's been able to recover monies for the creditors?
Yes, I have. Specifically with unfair preferences, had invoices outstanding to them. They've exerted a bit of pressure. They've managed to get payment. A couple months later, the company goes into liquidation. So then you have the liquidator demanding the payment that was received by the creditor within the 6 months prior to the company going into liquidation. So it does happen more often than you would think. There are ways that one can protect themselves and prevent that from being able to take place, or at least making it harder for the liquidator.